A debate that's going to be front and center next week with the Supreme Court when they take up Section 5 of the Voting Rights Act. Heard from both sides saying, there was record turnout, there was high turnout among minorities, among certain populations this current election cycle. Some people said, well, that just proves that we don't need these protections from Section 5. Other people say that, no, the exact reason that there was such high turnout is because we have these Section 5 protections. Give me a back and forth on why it's necessary, why it's not necessary in y'all's opinion.
Well, in terms of turnout isn't the full game. Of course, more minorities turned out because we're a higher percentage of the population. So that's easy to explain. What is more difficult to explain is why Texas is 50th out of 50 states in terms of voter participation. I mean, when we had a Texas governor running in 2000, we were 46 out of 50 states. When we had a sitting Texas president running in 2004, we were 42nd in 2000. We were 46th in 2004. When we had the very hotly contested Democratic primary in this state, and then the Obama phenomenon of 2008, where all these young people were supposedly getting out, we were 48th out of 50 states. And most recently, in the 2010 election, we were 50th. And if you equate civic participation with sort of strength of a democracy, then you recognize we have a lot of work to do. And I was concerned last session where the legislature moved forward with a new electoral photo ID standard that created the potential for up to 800,000 more Texans being disenfranchised, according to the Department of Justice numbers. And I was called, I was also deposed in that litigation and called, I only had a 4-hour deposition, but I think the Attorney General's office is very nice to me. But I was called by Attorney General Holder to talk about our experience in that photo ID debate. And just to be clear, I'm not against photo ID, never have been. I think you can create a photo ID regime that is contemplative of not leaving any Texan, validly registered Texan behind. And we offered a number of amendments related to that photo ID legislation that the court looked at. In fact, in the final paragraph of before striking down the photo ID legislation, the court said, hey, had you all adopted some of these common sense amendments, this would have been a much closer call. But it wasn't a close call. It was the strictest of all photo ID regimes in the country, and had the potential for a significant disenfranchising impact. In light of our experience last session, in light of the findings of courts related to intentional discrimination, I don't think they were saying that Representative Gonzales personally was discriminatory. I think they looked at the institution as a whole and the processes and inferred from what occurred that there was intentional discrimination. I don't believe Representative Gonzales was intentionally discriminatory at all. But I would say that the court did make those courts did make those findings, and we certainly need a Section 5 Voting Rights Act, because this stuff is no longer just in black and white and old-timey reels before in the movie theater. I mean, this was contemporary. This was in digital 3D that we saw it occur.
Representative, Section 5, as it pertains mainly to voter ID, we've gone through this.
Sure. Now, I had 7 hours of believe me, directly being blamed personally for this, so that stands as it is. I don't know how you legislate apathy. If people don't vote, there are a lot of reasons why people don't vote. I offer up something very different when I talk about voter apathy. In Round Rock, Texas, in one of our mayoral races, we had a 1% turnout. I mean, in a city council race, 1% turnout. And as you're in Round Rock and you're dealing with campaigns and polling and things like that, as you're walking around, you'll go through a very nice neighborhood, and you'll find yourself walking 8 to 10 houses before you find the next voter. Because where we live, the population is very mobile. They're not from Williamson County. They may not stay in Williamson County. They don't know the elected officials. They have a job, they're happy, and they're busy like everybody else my age, which is Williamson County, raising 2, 3, 4 kids. And so when I see voter apathy where I live, people are busy living their lives. They're busy running their businesses and running their families. And so voter apathy is very different for me. And that's something I've just come to learn in the last 2 to 4 to 6 years, really, as you look at where I live. So I don't know that it's discriminatory in that it's poverty or they don't have access, or these other types of things that we like to talk about. At least in my personal experience where I live, it's a very different kind of apathy. It's people are very busy. So I kind of look at it slightly differently, I guess, as far as that topic goes. That's not to say, though, that there's still, some issues out there. Representative Anchia references the 800,000 number on the disenfranchised voters. As you dig into that 800,000 number, you get some very interesting results. The methodology, as anybody here who's ever done statistics, the methodology of that is as important as the raw number itself, probably more important. So we called up and asked a few questions. How's this done? Well, the quick answer is a surname search. Great. My wife's name is Marie Elise Bowman, Gonzales. Under their methodology, my wife would qualify as a potential person who is disqualified from voting because of race discrimination. She is 100% Anglo. But as you look into the methodology of how they get those numbers, and there were 3, 4, 5 different instances that we got into a long debate about the numbers. And what are the numbers? That kind of getting into the details shows a lot of good information as well that never gets talked about, but it's really important to have that conversation because the methodology is as important as those raw numbers.